Welcome to the video tutorial for Topic 1, Apply Regulatory Powers. This unit describes the skills required to cover the exercise of powers under the organisation's enabling legislation and other relevant legislation for regulation, monitoring, inspection and investigation activities. It may be of assistance to have the unit learner guide open and available to refer to. In the learner guide, you'll find that the relevant parts of the learner guide are referenced in the title slide for that section. So for instance, the example on the screen, the first chapter of Apply Regulatory Powers learner guide, Establish Regulatory Powers, you'll see that the first part here refers to parts 1.1 to 1.3. This will assist you to navigate through the learner guide. Just of note for this topic is some of the short answer questions are out of synchronization, but we'll give you some guidance in relation to short answer questions when we get to them in the theory. So the assessment here in topic 1, there's two assessments. There's the short answer question assessment, of which we have 8 short answer questions, and also the practical assessment. So there's 4 questions to identify and explain different powers under relevant enabling legislation, and 4 questions to identify and explain elements of offences. And then 1 question relating to the failing to comply or a direction for failing to comply with a lawful direction. Please ensure that you read the assessments carefully. So as we progress through this theory, it's recommended that you have the assessment document for Apply Regulatory Powers short answer question assessment open, and in there we'll be looking to the questions will be appearing in the red boxed area of that assessment. For further information in relation to that, refer to the video tutorials in the course page. So in this lesson we're going to look at accessing current information relating to enabling legislation, understanding powers provided under legislation, and how to establish or understand the boundaries of those powers, identify and confirm compliance requirements, look at non-compliance and how to identify non-compliance, and then also break down that non-compliance or offences under legislation, looking for conflicting legislation and how to deal with that, and then also looking at overlapping jurisdictions and how to work with other organisations when required. So in this part we're going to look at the first chapter, Establish Regulatory Powers, parts 1.1 to 1.3. So in order to conduct your work as a authorised officer under legislation, you need certain powers to do that. You need those powers in order to gather the necessary information to enforce the legislation or to obtain compliance from those who are regulated by the legislation. So you need to understand exactly what those powers are that you have. And if you understand the powers that you have, then you're not going to overstep those powers and potentially create a situation where information is unlawfully obtained and could then be excluded from a subsequent court case. So you need knowledge of your enabling legislation and associated regulations. So the powers are generally aligned with the nature of the regulatory work that you do, and those powers will complement the need that you have or the requirements that you have to gather the information to conduct your investigations. So those powers are generally provided for you through legislation. The legislation or enabling legislation enables regulation through things like monitoring or inspection or audit, and then also powers to enforce through investigation. And that each enabling legislation will be specific to those needs of the area or the legislation which is governing the activity that's being regulated. So those enabling legislation is, if you're an authorised officer under a piece of enabling legislation, it is vitally important that you understand the scope of powers that you have and also the very particular requirements around using those powers. So the government implements or enacts powers for for authorised officers to use those powers to gather the information necessary. But the government's just not going to give you free rein as an authorised officer to do whatever you want, whenever you want, and however you want. So they put particular requirements around the legislation or around the powers so that those powers are used responsibly, ethically, all those sorts of requirements that the government places around those. So if you step outside of those requirements of the powers, then that power could be deemed to have been unlawfully used. And the subsequent flow-on effect from that is that anything you gather from use of that power could then be argued as inadmissible in any subsequent court case. So we need to make sure we understand those areas within our enabling legislation. So this is for regulatory or criminal type investigations. For workplace or disciplinary type investigations, we generally get our powers from what's called a delegation of authority or a delegation to investigate, which could be from a relevant delegate such as the Minister or the Director General or the CEO. And these are for investigations undertaken within an organisation for things like disciplinary or misconduct investigations. And those delegations can have particular conditions or particular requirements around them as well. So we need to understand or have that delegation and then understand the scope of the powers that we have under that delegation. The question to consider is, how has the digital age changed the way in which regulation or laws are enforced? And the way that the digital age has changed things is that the accessibility or readily accessible information on the internet has changed the knowledge or the power that the public have to gain knowledge in relation to, particularly around legislation. So before the internet, legislation was all printed format, and you had to actually purchase the legislation from the government printer. But now with the internet, everyone has access to it, which means that everyone can read it. The problem with that could be that the people will read it and interpret it the way that they want to, or to interpret it with the best intentions to suit their needs. So as an authorised officer, it is important again that you understand the scope of your powers and the particular requirements around those powers, because the person that you're enacting those powers against, in, for instance, entering onto someone's property, they may have read the legislation as well, and they might know that legislation very well, and they might understand the scope of your powers, and you don't want that person knowing the scope of your powers better than you do. So you really need to understand those powers very well. And so how do we get access, how do we get knowledge around that? Well, we have access to legislation websites. So every state, territory in Australia has their own legislation website, or there's other non-government sites such as AUSTLI. So AUSTLI, AUSTLII.edu.au is it's a legislation database. It has every state, territory legislation, and also case law and other relevant resources. So legislation websites is one way we can find our enabling legislation. We can also find them on our organisation's intranets. We can speak to or get information from our legal units. We understand or should be trained in our legislation, and also we may get assistance or guidance from mentors or other investigators around understanding our legislation. But as we said before, it's you need to understand the scope of your powers, so what powers you have available, but also understand the boundaries of those powers or the requirements to use those powers. So you've got the right to ask anyone any question at any time, but they have equally the right to refuse to answer that question unless you have the ability through a power under legislation to demand that information. So we need to understand where that scope of that lies in relation to each of the powers that we use, and those boundaries can differ from one power to the next and from one piece of legislation to the next. But there are some very common ones that we'll cover or look at in this unit. So before we can use enabling legislation and the powers in that enabling legislation, we first of all have to be delegated the authority to use that. So in each piece of legislation, you will generally find sections within that legislation which define how someone is authorised under the legislation, who can provide that authority. Maybe there might be a section in your legislation which talks about particular conditions that can be put on the use of an authority, or how long an authority might last. So those sorts of things are all come down to the ability to authorise a particular person with particular skills or knowledge or education, and the term of their appointment and any conditions of their appointment. If you look at legislation, any regulatory legislation, and you look at the powers will always have an authorised officer may, or an inspector may. It doesn't say a person may, because if it said a person may, that would mean that anyone could use those powers. So it's the terminology in relation to an authorised officer within legislation can be specific to that legislation. So it'll be terms like authorised officer, authorised person, inspector, investigator perhaps, but you generally find that it's somewhere around that authorised officer, authorised person, or inspector. Words like that will define the person who has the authority, and that could be particular to a section as well. If you have inspectors and authorised officers under a particular piece of legislation, there might be particular powers for inspectors, there might be particular powers for authorised officers. So it's about reading the sections in the legislation carefully to understand exactly what power, who is delegated the authority under the power that you're reading, and then understanding what boundaries, requirements, and the scope of the power that person has. So the boundaries or requirements within a power, we refer to them as conditions and responsibilities. So first step in understanding your powers is to first identify the power that's available to be used, and then read that power, read that section, and then ask yourself, well, what conditions or precursors must I satisfy before I can use that power? And then also look at the power and say, well, what responsibilities do I have when I use the power? So conditions are the precursors, are the things that you need to satisfy before you use the power. And the responsibilities are the things you need to satisfy when you use the power or after you use the power. Now, it's probably fair to say that conditions and responsibilities can be very close in terms of reading a section. You go, look at something, you'll go, well, that looks like a condition to me. And someone else might read that section and go, hey, no, that's a responsibility. Don't get hung up on arguing or deciding whether something's a condition or a responsibility. The important thing to understand is that you read the section or read the power, you identify that you need to do something, whether it's before, during, or after the use of a power, and you do it, and you satisfy those requirements. So we spoke before about the common law rights everyone has, and that powers are put in place to override certain common law rights. So therefore, as we discussed earlier, those powers will be bound by requirements to ensure that the powers are used responsibly. So that's the conditions and responsibilities that come with the use of the power. It's not just a free-for-all. You don't just get a power to enter someone's premises. You generally, along with that, you need to satisfy the conditions of the entry. So if you can't satisfy the conditions of the entry, then the entry can be deemed unlawful. Now, enabling legislation and powers that come along with it will not sit in isolation. There will be other things that will influence. And one of the things that will influence it is procedures and policies of the organisation. So the enabling legislation is usually written quite broadly, and then the procedures and policies will further define how the powers are to be used in accordance with the organisation's or the regulatory organisation's expectations. So things like a power may include the power to execute a search warrant. However, the organisation only wants certain qualified people in the organisation to execute a search warrant. So their procedures and policies will dictate that only certain people with certain qualifications are able to execute a search warrant under the enabling legislation. Also influencing it will be case law, codes of conduct, and other legislation. So other legislation will be things like privacy legislation. Work health and safety is another one. So you may have under enabling legislation the power to enter onto someone's property. However, because you've got that power to enter onto someone's property, doesn't mean that work health and safety legislation is excluded from the way in which you do that. So other legislation will influence the use of enabling legislation. We'll talk more about that a little bit further on in this unit. We need to have a comprehensive understanding, particularly of policies and procedures, because they can also influence court proceedings later on. So even though you got the power under enabling legislation, a defence solicitor may be able to argue that you didn't follow policy or procedure of the organisation, and also then go on to argue that perhaps the power wasn't used in accordance with the expectations of the organisation. It wasn't utilised fairly. So that's conditions, responsibilities of powers. And we're going to look at a couple of examples in our practical assessment a little bit later on. We're now going to look at part 1.4 of chapter 1, which is about offences and elements of offences. This is a very important skill to have as an investigator. So identifying offences, to determine the precise nature of a prescribed conduct, you need to analyse the legislation and define the offence or offences. Quite often just a mere act is not sufficient for a criminal liability. So we look at a set of circumstances and we need to look at, well, what acts or omissions that are being done or have been done in this situation that might indicate or might constitute an offence or offences under the Act. Now we all know what an act is the physical act of doing something. An omission is failing to do something. And equally those two things can constitute an offence. So how do we break down offences? So first of all, we need to analyse and define the offence or offences we potentially are looking at in terms of the act or omission that the person has done. We need to prove each element or part of the offence. So that's why we determine elements of the offence, because those are the component parts of the offence we need to prove to the court in order to prove that the offence has occurred. So elements can be aligned to or equated to ingredients like cooking a cake. So elements are like the component parts of the ingredients in order to cook a successful cake, where you have enough of the elements, enough of the ingredients, you combine them in the right order, and you have all the ingredients in place, then you have a successful cake. So when everything comes together properly, the offence is proven, and we get a good cake. When we don't have an ingredient, or we may not have enough of an ingredient in a cake, then the cake can fail. Similarly, if we don't have enough evidence in an element, or we can't prove an element, the offence isn't proven, and therefore the case will fail. So to identify and confirm offences under legislation, we need to look at the circumstances that are being presented in the situation that we're investigating, and we need to identify or understand the potential offences in the legislation, and we can determine more than one offence, but determine the most likely offence that has occurred through understanding the incident and determining the acts or omissions that constitute a particular offence. And then we focus on that offence and we go, okay, so what are the elements that we need to prove? or question 4 of your short answer questions, this information would be useful. So every offence consists of a series of subcomponents known as elements or proofs. So the elements are the specific acts or omissions that go to creating particular offence. Now they can be, there are different types of elements, and we're going to talk about those in a moment, but the component parts of the offence are made up of those elements. And the primary element is the act or omission that goes to creating the particular offence. So each element must be proven in order to prove the offence. So therefore, if we're looking at offence number 1 there, such as the on your screen in the example, but we can't prove one of the elements of that offence, but through the evidence we've gathered, we may be able to prove another offence under the legislation, and we can then move to taking action under that offence rather than the original offence that we looked at. Understanding or determining the elements of the offence can also be very useful and assist us with investigation planning, because once we understand the elements, we can then decide, well, what is it we need to go and get? What information do we need to prove the element? And then we can plan to do that in a structured way. And so it helps us with evidence collection. So what evidence do I need to prove the element? And then also it can help us with our investigative interviewing, because we plan our interviews around the elements, and we always make sure that we cover the elements in our investigative interviews. So here's an example of an offence provision from the legislation, the dummy legislation that you'll be utilising for the practical assessment here. For those of you who haven't already found it, it's the Environmental Development Act. It's available on your course webpage. Also, what we're going to discuss here will be helpful with short answer question 5. There are different types of elements, as I discussed earlier. Different types of elements. The first type of element is what's called common elements. So common elements are elements which are common to every offence. They exist in every offence and must be proven. So the common elements are the date of the act or omission, the place of the act or omission, the jurisdiction, and the person criminally responsible. Now, out of those 4 common elements, the 3 key ones are the date, the place, and the person. Jurisdiction in relation to this is court jurisdiction. Now, each offence will have a specific court jurisdiction. So, summary or simple offences are generally court jurisdiction of the magistrates' court or the county court in some jurisdictions. And then for indictable offences, the jurisdiction is generally the state or territory where the offence has occurred. But understand that common elements are common to every offence, so they have to be proven. Then the second key part of elements is called specific elements, and those specific elements are then the elements that are specific to the offence itself. Specific elements are further broken down into what's called physical elements and fault elements. Now, physical elements are the physical acts or omissions that go to constitute the offence. So in Latin, the term is actus reus, or the guilty act. So out of the example offence that we have on the screen, the acts or omissions that go to constitute the offence, there's actually, you can break those down into 3 separate elements. So the 3 separate elements of acts or omissions are that, first of all, environmental development was commenced. So if we can't prove that environmental development commenced, then we can't prove this offence. The second physical element that we need to prove is that the environmental development caused degradation. And the third physical element that we need to prove is that the environmental development was commenced without an environmental impact statement. So there's 3 physical elements we need to prove. So we need to prove, just go over that again, we need to prove that environmental development was commenced. We need to prove that it caused degradation, and we need to prove that it was environmental development was commenced without an environmental impact statement. So those three things need to be proven. If we can't prove any of those three elements, then the offence can't be proven. Now, generally an offence will have a primary act which constitutes the offence. And in this example, the primary act is the commencement of environmental development. So the date and place of common elements, date and place, would be the date that the environmental development commenced and the place where the environmental development commenced as the primary act, because it's then that primary act of commencing environmental development that has the subsequent physical elements, that it caused degradation and that it was done without an environmental impact statement. So the idea behind determining elements of the offence is to break down the offence into basically like bite-sized chunks of things that we need to prove. So we want to make it succinct statements of what parts of the offence we need to prove. So you could say, look, the element is that environmental development commenced, that it caused degradation, that was without an environmental impact statement. But there's three separate things literally that we need to prove. So we're better off breaking those down into three separate elements rather than one big element. The other part of physical elements is that the act or omission was done voluntarily. So that it was done without duress, it was done without threat. So the act or omission was voluntary. We need to ensure that when we're doing gathering our evidence. The other specific elements are what's referred to as fault elements. And fault elements are the guilty mind, mens rea. Not every offence will have a specified fault element. There's two fault elements to prove in this offence. So the first fault element is that the person intentionally or recklessly commenced environmental development. The second fault element is that the person commenced environmental development knowing that environmental degradation will or might result. So they knew that the environmental degradation will or might result, and they intentionally or recklessly commenced the environmental development. There's two separate fault elements that we need to prove in this offence. Now this particular offence provision pops up later in our practical assessment. So the combination of physical elements and fault elements with our common elements combine to make out our elements of our offence that we need to prove. The other thing that we need to be mindful of as we're going through this process is definitions. Definitions, they're specific definitions to enabling legislation, then that enabling legislation will have reference to a definition. For instance, in the Environmental Development Act, you'll find that there's a particular definition for environmental development. You may also find a definition for terms like environmental degradation. So in order for us to prove this offence to the requirements of the court, the commencement of environmental development has to be within the definition of what environmental development is. Other things you may want to look at in terms of definitions is environmental impact statement. What is an environmental impact statement? For question 6, you're looking at your understanding of the legal definition of the term recklessness. So on the screen here is the legal definition of recklessness, and I'd give you a moment to pause the video and read that definition. Now that you've read the definition and had a look at it, you need to understand what it means. For recklessness to occur, first of all, the person did an act that constituted an offence or a harm, but they didn't intend for that harm to occur, but they knew that it was a likelihood that the harm might occur, but they still took the chance of doing it. So if I throw a rock at a window and the window breaks, and I say, well, I didn't intend for the window to break, but I knew that the window might break as a result of my act, then I'm equally compelled I'm equally responsible under recklessness. By way of an example there, we look at a case in relation to the Queen versus Denbo. So what happened was a construction company purchased a truck, and at the time of purchasing the truck, they were informed that there were faulty brakes on the truck, and the company took no action to fix the brakes and gave the driver of the vehicle, of the truck, no training or proper instruction. Now, tragically, the truck overturned and the driver was killed in the accident. Now, the corporation was found liable and the director charged because of recklessness and successfully prosecuted for manslaughter. The principle of the guilty mind in purchasing and using of the mechanically unsound truck was negligent. A reasonable person would have exercised some foresight to fix the faulty truck, or at least advise the person driving it. So as a result, they were deemed to be reckless, and a finding of manslaughter was handed down. Now, proving fault elements is quite difficult because you've got to prove the guilty mind. So the best way to prove fault elements is through admissions. So someone admitting, yes, I did it and I knew it was wrong, I intended for that action to occur, that is the best way to prove fault elements. You can also prove it through certain circumstances or through false denials. Now, false denials are where someone continues to deny responsibility even though we have overwhelming evidence to the contrary. So just in summary, acts or omissions determine the offence that we're going to look at. And then breaking that offence down, we need to look at what are the common elements. Time may be a component part, but certainly not an element in terms of a specific element. Date is always the specific element. And the date can be on a particular date, on or about a particular date, or between dates. Then we look at the other common element of place and identity or person responsible. Then we look at the specific elements of the offence, so the specific acts or omissions, and in terms of the physical elements, the specific acts or omissions, and the fault elements being the guilty mind. So the intention, recklessness, willfulness. So let's break down and quickly show you how to break down an offence provision into its component elements. Now this may come in handy for you for your practical assessment a little later on. So the other thing that we find it's a good practice to get into is as you're breaking down the elements of an offence, have the offence provision there in a print format, and as you write an element, cross out the part of the offence that element covers, and if you've got everything crossed out at the end of that process and you've covered everything, you have to cover everything in an offence provision with elements. Now the elements should be a succinct, simple statement relating to the element. So the first thing we talk about is looking at what is the key physical act that we need to prove. Now this is the same section we talked about earlier. So we said the key physical act that we need to prove is that environmental development commenced. We write that down, so evidence that environmental development commenced. So, and then we cross that out. So along with that physical act of environmental development commencing, we said this is also associated with our common elements of date and place. Now, some methodologies to doing elements had date and place as two separate elements, but our process combines those two common elements into the primary physical element, because as you prove that physical element, you're going to be proving also date and place. So you're not going to duplicate or even triple the effort to write up your evidence later on against three elements. So you're going to include in this primary element the notation that it includes date and place as our common elements. So the second physical act we need to prove is that the evidence of the environmental development caused environmental degradation. And we cross that out. And the third physical thing that we need to prove is that it was environmental development was commenced without an environmental impact statement. Okay, and we cross that out. So that's our process. First step of our process is to identify the physical acts that we need to prove. We then write up our common element of identity. So we identify evidence of the identity of the person. So evidence of the identity of the person responsible for commencing the environmental development. Now, what is left are any fault elements that relate back to the person who is criminally responsible. We then write up the first one being that the evidence of the environmental development was intentionally or recklessly commenced. And the second fault elements, evidence that the person knew that environmental degradation would or might result. You can see there that now we've taken that offence provision and we've written it into 6 succinct elements to prove. And through those elements we can now go and look at, well, what is it that we need to gather, what information or evidence do we need to gather to prove one or more of those elements. And remember, we need to prove all of those elements in order for the offence to be proven. We have offence provisions and machinery provisions. So question 7 relates to this. Offence provisions. As a general guide, offence provisions are provisions which contain reference to an imprisonment or a penalty. They are the definitions of the wrongdoings in the legislation. Machinery provisions are provisions within the legislation designed to expand on the operation of the Act. Now, one example that we could use there in relation to a machinery provision is in some legislation where you've got many different variations of parts to it. For example, a weapons legislation where we have many various different types and grades of weapons. The legislation will have what's called schedules. So those schedules compartmentalise different types of weapons into particular schedules. So you'll have a Schedule A weapon, Schedule B weapon, etc., etc. So, and those schedules may contain any number of different types of weapons. So instead of having an offence provision for every individual weapon that's potentially available to possess, then the machinery provision is the schedule, and the offence provision will say it's an offence to possess a Schedule A weapon. And then the schedule will expand on that to define what a Schedule A weapon is. So I hope that explains machinery provision a little bit better for you. So Chapter 2, Apply Regulatory Powers. We're looking at parts 2.1 to 2.4. It's important to understand circumstances outside of your limits and refer, where necessary, to other jurisdictions. So question 1 here, we're talking short answer question 1. You're looking at, where you're enacting your enabling legislation, you need to understand the scope of that legislation and the boundaries around that legislation to ensure that you don't overstep that mark. So if you, for instance, in the question, in short answer question 1, we're talking about being lawfully on the premises under the Environmental Development Act, but you find malnourished animals and a weapon, a firearm. Now those two things that you find potentially constitute offences, but are they offences which you, under the Environmental Development Act, are authorised to deal with? And the answer to that question is no. So then what do we do with that? Well, we need to look at referring that on to another agency which has the expertise in relation to that. So before we act on something that we find as part of our investigative process, we need to confirm that the breach actually falls within our jurisdiction. And if it's not within our jurisdiction, we need to look at what is the most appropriate jurisdiction to conduct the investigation. And we need to do that because essentially that jurisdiction will have the appropriate powers and offence, the ability to charge or to take action for particular offences relevant to that conduct. What we become then, importantly to understand, is that as an investigator for something that's outside of our jurisdiction, we essentially become a witness. So we need to take appropriate action to ensure that our evidence as a witness is recorded appropriately, and where we can, lawfully gather evidence in relation to what we observe. Okay, and then we refer to the relevant agency. Now, it may also be important to understand that we may not want to tip off someone to the fact that we've uncovered or we've become aware of another offence or another potential wrongdoing, because by the time the agency or the relevant agency is able to attend and deal with that matter, that particular act or omission may be gone. So, for instance, in the example in question 1, if we ask the owner of the property about the malnourished animals and alert them to the fact that we are aware of them, then by the time the relevant authority, the RSPCA or Animal Welfare, attend to deal with that matter, those animals may have been moved or hidden somewhere. So it makes the investigator's job a lot harder. Risks are always apparent in our regulatory environment. Okay, we need to understand that risks are everywhere in relation to an investigation process. So risks will generally centre on the acquisition of evidence. However, there's so many other parameters that we need to be aware of in terms of regulatory powers. Particularly, no one likes to have action taken against them in relation to a breach of legislation. So emotions become frayed, and we need to be aware that what we're doing, even though it's the right thing, may not be well received by those who we're taking action against. So we need to make sure that we understand those risks and manage the risks appropriately. What we need to do is put together a risk management plan, looking at the objectives, what must be done to achieve those objectives, and looking at potential risks or barriers that we need to overcome. Okay, so the potential risks associated with the powers you're about to exercise. So this refers to question 2 of your short answer questions. You're about to go into a situation which is potentially has high risk associated with it. So you want to be doing some forethought about what potential risks we're going to encounter and how we might gather information to inform ourselves of the extent of the risks that we might be walking into in terms of executing a search warrant in a high-risk situation. We might look at what actions we can take to eliminate or reduce the risks. So, for instance, if we're going into a high-risk situation, do we need to take additional resources with us in terms of personnel, police perhaps, or have police on standby, things like that. We also need to remain vigilant in relation to our risks and have a plan about how you're going to react if those risks actually eventuate. So if we're on site or about to go on site, what sort of things are we going to look for in terms of updating our information on the risks that are presented? So for instance, if you're about to go into a high risk search warrant situation, you're outside the property and you see that there's 20 cars parked around the property and out the front. Might be an indicator that there's been some sort of a gathering there, and you might be walking into a potentially large group of people. So that may not be the appropriate time to be entering. So other risks, things like animals, dogs on the property, things like that. We need to counter the risks that are being managed versus our plan to react to those risks. So if we're executing a search warrant, we may not necessarily need to have the SWAT team on standby or things like that. So we need to be reasonable in our approach to executing the plan based on the risks that we've identified. Okay, so Chapter 3, utilising other legislation and standards. So Short answer question 3 talks about 3 pieces of legislation that may impact on your enabling legislation. Well, we've already touched on that earlier in this tutorial. So things like the Privacy Act. So regardless of, we're collecting a lot of information as an investigator, and we might have the lawful power to do that, but we still need to comply with privacy requirements and privacy legislation in relation to the information that we do gather. We need to also consider the Public Service Act, which dictates how we conduct ourselves as a public servant. We might need to consider the Criminal Code. The Criminal Code, things like if we're on property, on someone's property, and it's deemed to be an unlawful entry onto the property, then that we may be breaching trespass laws under the Criminal Code. And of course, work health and safety. You have to be safe all times at work. So regardless of our enabling legislation and what powers we have, we still have to act in accordance with work health and safety. And you also might need to consider legislation relating to freedom of information. Working with other jurisdictions, it's advantageous because we usually get a wide range of perspectives and experience, skills. It can also help us reduce the burden and share the load, essentially. And we can also learn a lot from other jurisdictions in the way that they operate their practices. So with question 8 there, though, you're talking about examples of an overlapping of other jurisdictions. So where you have an overlap for another jurisdictions might be things like geographical, where the AFP might work with another international police agency on a smuggling situation, a smuggling investigation. So you might work with other geographic jurisdictions, other agencies across borders, if the offence is one which covers that sort of jurisdiction. Also of assistance are things like lines of communication. So lines of communication are important, and there's 3 basic lines of communication that we use. The first one is a memorandum of understanding, or an MOU. So it establishes the principles for conducting multi-agency jurisdiction investigations. And investigative agreements, a joint investigation established through an MOU and the signing of an investigative agreement. And a joint management committee. So it's formed as a result of an investigative agreement, and it oversees the investigation, determines strategies in line with the principles of the MOU. That's an overview of the key parts of the theory. There is more information in your learner guide, so please refer to that. And we're going to undertake a bit of a review of our practical assessment. So at this point, I would recommend that you pause this video and you open up your practical assessment and prepare to take some notes down in relation to those questions. So on your screen you'll see the practical assessment and the Environmental Development Act, which we're going to use to refer for these questions. So for question 1, now with these practical assessment questions, very important that you don't just copy and paste relevant sections from the legislation. You need to demonstrate that you can read the legislation and understand the legislation, interpret it and describe conditions, responsibilities and elements using your own words. Copying and pasting sections in as your response will not be accepted. So let's have a look at the first one. Question 1, identify the power you rely on to enter a place. So if we have a look at our contents, we're looking at powers of authorised officers. So we need to go to part 5 of the Act. So part 5 of the Act, authorised officers. So we need to look for a section which relates to entering a place, and just to assist you with this one, the first one here, section 54, power to enter a place, is the section that we're looking for. So part 1 of that question, identify the provision under which you are entitled to use the power. The answer to that, section 54, power to enter places. So part B lists the conditions precursors that must exist before the power can be used. So let's look at subsection 1 of this section 54. So an authorised officer may enter a place if. So if we take that, just that section there, are there any precursors or conditions that we need to comply with in order to use section 54? And the answer is yes. So the things we need to satisfy are that, first of all, the person is an authorised officer under the Act. So an authorised officer under the Act relates to being an authorised officer under section, or authorised or appointed under section 48 of the Act. So the first part there to write in relation to that is that you must be in relation to conditions. So over here in your response, you must be an authorised officer under section 48 of the Act. Another condition that we need to make sure that we comply with is that entry that we're making is entry to a place by definition. So we need to be aware that if there is a definition of a place within the legislation, that we are complying or entering a place by definition under the Act. If we don't enter a place by definition under the Act, then we've misused the power. Have a look in the definitions of the Act. There's a definition for a place outlined. So we need to make sure that where we're entering is under that definition. So under subsection 1A, B, C and D. So you can enter a place if the occupier of the place consents, it's a public place, and entry is made when it's open to the public. The place is subject to development approval and the entry is authorised by a warrant. These four, A through to D, constitute four separate conditions under which we can enter the place. So each of these constitutes a particular condition for entry. So the entry for conditions, the entry can be made if the occupier consents under 54(1)(a), or it's a public place open to the public under 54(1)(b), or it's a place subject to a development approval under 54(1)(c), or the entry is authorised by a warrant under 54(1)(d). So there's four different conditions that can be used to gain entry. Now these are all different conditions because they're separated by an or. If they were and, then we would need to comply with all four conditions. We move to subsection 2 for the purpose of asking the occupier to place consent. Subsection 2 there, if you have a read of subsection 2, is essentially saying that the authorised officer can enter onto land to ask for permission or ask for consent as part of the use of section 54. So does it place any conditions on us? Essentially no. It's a mechanism or a machinery for us to be able to get on to ask for consent to enter. In terms of power to enter places, that's it for conditions, and section 54 places has no specific responsibilities in relation to enter of the place. However, a common responsibility for every use of every power is a responsibility to identify yourself as an authorised officer. If we look at section 53 of the Act, section 53 says produce or display identity card. An authorised officer may exercise a power including entering land under this Act only if the authorised officer first produces his or her identity card for inspection or has the identity card clearly displayed. So we need to comply with section 53. It's a responsibility that we need to do when we're using the power or on using the power, section 54. So in terms of responsibilities in our response over here, part C, responsibility is that we produce or display our identity card in accordance with section 53 of the Act. Section 54, the occupier consents to the entry, 54(1)(a). We look at section 55, an entry with consent has certain requirements to be met. So we have responsibilities under section 55 where entry is made under section 54(1)(a). So these need to be thought about in terms of our responsibilities. So subsection 1, section implies the authorised officer intends to ask an occupier for the place for consent to enter the place. Subsection 2, before asking for the consent, the authorised officer must tell the occupier the purpose of the entry and that the occupier is not required to consent. This constitutes a responsibility that we have in order to gain entry under section 54(1)(a). So in our responsibilities, in our response here, we have the responsibility to notify the occupier of the purpose of the entry, and then the person is not required to give consent under section 54 to under section 55 subsection 2. Section 55 subsection 3, if the consent is given, the authorised officer may ask the occupier to sign an acknowledgement of the consent. The defining term here is may ask the occupier to sign an acknowledgement of consent. So that doesn't, if that said must, then that would constitute a responsibility. Subsection 4, however, the acknowledgement must state A, B, C and D. Okay, so this places a responsibility on us. If we're going to ask for consent and get them to sign an acknowledgement, we need to comply with section 55 subsection 4. So we need, in responsibilities, a signed acknowledgement must state the information as contained in section 55 4A to D. Okay, so we need to make sure that we acknowledge that the responsibility is that a signed acknowledgement must be or must state requirements as per section 55 subsection 4A to D. And subsection 5, if the occupier signs the acknowledgement, the authorised officer must, there's that word again, must, immediately give the occupier a copy to the occupier. So that places a responsibility on us. So in response to question 1, in our responsibilities, if the occupier signs an acknowledgement, the occupier must be immediately given a copy of the acknowledgement under section 55 subsection 5. 55 subsection 6, a court must find the occupier of a place did not consent to an authorised officer entering the place under the division if, so this relates to the court finding. So this relates to court matters, doesn't place a responsibility or condition on the use of the power, but rather it places a responsibility on the courts in terms of finding whether entry was authorised or not. So it's no condition or responsibility on the authorised officer, so therefore it is irrelevant to response to this question. So to write up this question, you need to, or for correct answer would be to have conditions relating to the authority, being an authorised officer, condition relating to it being a place, and the 4 conditions under which entry can be made, A through to D. We need to consider responsibilities of identifying ourselves under section 53. We need to display or produce or display our identity card. And responsibilities associated with section 55, where entry is with consent, to make sure that we comply with subsections 2 and subsection 4 and subsection 5. Okay, so that's question 1. When we move on then to question 2 talks about a power to require information. Now I'll give you a hint here. We're looking at a particular section in the 70s. So in the sections in the 70s in the Act. So look at sections starting from section 70 through to section 80 and you should find a section in there relating to requiring information. There are a number of conditions that need to be met, and there's not a huge amount of responsibilities. There's only a couple in there to think about. Question 3, pretty straightforward. You should be able to find the power to require name and address. Again, look in the 70s. With question 4, very important that you read the question carefully, or the circumstances carefully, because there are particular specific circumstances that you need to look at. Then look at the section relating to gathering or seizing evidence. Look for the power to seize evidence. It's in the 60s, I'll give you that hint, it's in the 60s. The power to seize evidence. Read that section and relate the particular conditions or particular circumstances, executing a search warrant, exhibits not mentioned on the warrant. However, you believe the evidence will be destroyed if it's not seized. Very particular in that section, so look for the particular conditions of responsibility relating to those circumstances. So that's it for the conditions and responsibilities of powers. And we're now going to move on to question 5 through to question 8, being the elements of the offences. So question 5 would be very familiar section to you. Section 44, subsection 2, unlawful development causing environmental harm. So we have a look at our offences section, which is part 4 of the legislation. Part 4 being offences. Section 44, subsection 2. That section should be quite familiar. Think back to what we did in our example in the theory earlier, and you should get some assistance with that one. With question 6, section 45, subsection 1, very short offence provision. We're really only looking at 3 elements. So first of all, we need to prove a particular approval existed. Second element should relate to what was done that breached that approval. And the third element is the common element of identity. So there's really only 3 elements there. If you follow our formula, write out those elements in succinct statements. Question 7 relates to 46 subsection 2, false or misleading statement. Again, quite a short offence provision. But when we're looking at it, we'd be looking for you to identify 4 elements, 2 physical elements that relate to the statement, and one of the physical elements will incorporate the common elements of date and location. Same with section 45, subsection 1. One of the physical elements in section 45, subsection 1 will incorporate common elements of date and place. We also have to utilise the common element of the person criminally responsible. And there's also one fault element in section 46 subsection 1. There's a fault element that we need to identify. Important to understand the term material particular. If you don't understand the term material particular, do some research. There's information available about that term, that legal term, material particular. Question 8 is section 47 subsection 1, obstructing an authorised officer. So I'll leave you to do this one on your own. So having the guidance that we've given you to this point, you should be able to do question 8 on your own. And question 9, create a verbal response that you might give someone who indicates they intend to refuse to comply with a lawful direction. Now, if you in your organisation or you in your regulatory role have a standard warning that you use, then feel free to use that and put that in as your response. Otherwise, follow the example that's given. So we give you an example in the assessment document, and do not use language which could be labelled as threatening or inducing in your requirement. So there's a hint for you. Okay, so avoid language which might be seen to be threatening or inducing, okay, in terms of your language. Alright, so that is the theory and coverage of the practical assessment for you. So good luck with that. We'll see you in topic 2 tutorial.